Welcome to the Family Freedom Caller, brought to you by the Texas Homeschool Coalition and the Family Freedom Project. At the Family Freedom Project, we recognized some years ago that it was not enough to pass new laws when government agencies and sometimes individuals would simply ignore the law, especially when facing families with limited resources. Therefore, we began to pursue litigation to protect families, but also to clarify the law and to set precedents, legal precedents, on the kind of issues where parental rights were being assaulted. While we were very successful in the legislative session in 2023 in passing legislative reform to CPS, there were some critical parental rights issues that we were pursuing at the Supreme Court of Texas. We were overjoyed with the response of the courts in two cases. In the first case, the court released an opinion reining in the power of CPS. In the second case, the Supreme Court of Texas declined to review a strong and favorable defense of parental rights issued by a court of appeals here in Texas. This leaves the favorable Court of Appeals opinion in place, a great win for parental rights. Let me give you the details. Case number one, reining in the power of CPS to terminate parental rights over bureaucratic technicalities. Last fall, the Supreme Court of Texas heard oral arguments in a case, and that centers on whether Child Protective Services, or CPS, can terminate parental rights based on a parent's failure to fulfill technical administrative requirements imposed by CPS. The court emphatically held that due to the constitutional weight of parental rights, termination cannot occur solely for failure to check off inconsequential bureaucratic tasks set up by CPS. Parental rights may only be terminated if important, court-ordered tasks are explicitly outlined and the parent substantially and critically fails to fulfill them. The ruling underscores that termination should not hinge on a minor technicality, but rather on a parent's failure to address significant and essential responsibilities as mandated by the court. Chris Branson, a senior fellow at the Family Freedom Project, filed a brief on behalf of the Family Freedom Project in this case with the Texas Supreme Court, arguing that courts should strike down the law as unconstitutional or else narrowly interpret it to ensure that technicalities don't tear families apart. Justice Huddle delivered the opinion of for the Texas Supreme Court, emphasizing the fundamental right of parents to make decisions regarding the care, custody, and control of their children. The ruling underscores that the state must demonstrate to a court that governmental intrusion is warranted before the infringing on the parental. Justice Huddle delivered the opinion for the Texas Supreme Court, emphasizing the fundamental right of parents to make decisions regarding the care, custody, and control of their children. The ruling underscores that the state must demonstrate to a court that governmental intrusion is warranted before infringing on a parent's rights. The court clarified that termination requires clear and convincing evidence of noncompliance with a specifically established requirement in the written court-ordered service plan. The court ultimately found legally insufficient evidence to support termination in that case and reversed the judgment, rendering a decision in favor of the parent. This is a huge win for Texas parents and families. In the second case, titled In Re NH, the Supreme Court of Texas denied an appeal by a non-parent who was seeking to usurp the rights of the child's biological parent. This denial upholds the good opinion of the Court of Appeals, and according to the Court of Appeals, the judges are not permitted to interfere in the parent-child relationship unless it is necessary to protect the child from significant harm. Cecilia Wood, a family law attorney from Austin and a longtime partner of the Family Freedom Project, filed a brief on behalf of FFP, arguing that a court should never be able to intervene in a parent's decisions for the child unless it is necessary to protect the child from significant harm. This case resulted in a partial but still significant win for parental rights. The Family Freedom Project has now sought clarification from the Texas Supreme Court 3 times, regarding what standard judges are required to follow when considering a possible intervention in the parent-child relationship. The court has ultimately declined to specify the answer in all three cases. So the Family Freedom Project has consistently argued that no intervention can be justified under the U.S. Constitution unless that intervention is necessary to protect the child from significant harm. Significantly, the Court of Appeals in this case has previously issued an opinion agreeing with this exact position. And while the decision from the Supreme Court of Texas today leaves this favorable Court of Appeals opinion in place, the Supreme Court of Texas declined to issue its own opinion, which would have settled this critical legal question on a statewide basis. As a result, different trial courts and appeals courts will continue to reach different opinions on this issue until the Supreme Court of Texas finally decides to intervene and settle the question in a statewide position. The Family Freedom Project will continue to defend parental rights in the courts with the aim of ultimately resolving this critically important issue at the Texas Supreme Court. At the Family Freedom Project, we are dedicated to defending parental rights in the state of Texas at the legislature and before the courts. And as we celebrate these victories, we are aware that there is still much more work to be done. We still have 2 cases pending before the Supreme Court of Texas for which we have filed briefs. One is defending Senate Bill 14, which outlawed the gender transition surgery for minors. That case is an appeal by the ACLU, which is arguing that parents have a fundamental right to make medical decisions for their children, and therefore, parents should have the right to make decisions in these cases. We have argued, of course, that parents do have a fundamental right to make medical decisions for their children, but they do not have a right to do so in cases that bring significant harm to these children. The other case is another CPS case related to child endangerment. CPS is often treated certain conduct as de facto harm to a child, even if no harm occurred and no specific risk was posed to the parent's actual child. So as seen in this case, CPS contends that any drug use, regardless of its impact on the children's safety or well-being, justifies automatic parental rights termination. Thus, whether a parent became addicted to prescription drugs by accident or whether they run a neighborhood drug ring may be seen as the same in the eyes of the law. We contend that to terminate parents' rights, the rights granted by God as protected as fundamental under the U.S. Constitution, CPS must establish the specific circumstances of danger to the child that necessitate that termination. A theoretical risk of harm to a theoretical child is not enough. When CPS removes a child from their home, the harm done to that child is not theoretical. That harm is tangible and often lifelong. When considering whether to remove a child from their home, then CPS should be required to prove an actual risk of harm to the child. So share this podcast with friends and subscribe to the Family Freedom Caller wherever you get your podcast. For more information about THSC, go to our website at thsc.org. And for information on the Family Freedom Project, go to familyfreedomproject.org. And thanks for helping us keep Texas families free.